My name is Thomas Gils, and I'm a research associate at CiTiP, the Center for IT and IP Law at the KU Leuven. And in that capacity, I also work for the Knowledge Center Data and Society. Now, a few practical arrangements before we continue. You should be muted by default, and your camera should also be disabled by default. But should you be able to change that, please keep them muted and disabled for the continuations of this webinar. Now, a quick note on the Knowledge Center Data and Society. The Knowledge Center is the central hub in Flanders for the legal, social, and ethical aspects of data-driven and AI applications. It was established under the Flemish Policy Plan on AI and pursues several objectives. And two of them are actually being put into practice today. One of them is disseminating information and knowledge to the stakeholders in the AI ecosystem. And another one is also contributing to the development of legal frameworks and guidelines. Another example of this second objective was a publication of our policy prototyping report, which was the result of our prototyping project, in which we tested the EU AI Act's transparency requirements, more specifically the instructions for use for high-risk AI systems and disclaimers for AI systems with specific transparency obligations, as will be explained later by Abdullah. If you're interested in that policy prototyping report and project, definitely check out the site of the Knowledge Center or reach out if you wish to obtain more information. Finally, also clarify that the Knowledge Center is not only made up of CiTiP, and that we also work together with a research center at the VUB, the Free University of Brussels, called SMIT, Social Scientists, and also MICT, which is a department of the University of Ghent. Now, luckily for today's presentations, it's not just me who will be presenting on these topics under the AI Act, but I'm joined by 4 of my CiTiP colleagues. Matteo Frigieri will enlighten us all on the scope of application of the AI Act. Abdullah Elbi will address the risk categories under the AI Act. Ivo will address the general purpose AI models. Also an interesting notion. And finally, Katarina Jordanova, will address regulatory sandboxes, which is also quite an interesting concept. Ideally, we will be speaking around 10 minutes for each topic, and then at the end, we will do a Q&A. So in order to ensure the stream of this presentation, we will take questions only at the end of the presentation. And so let's dive right into the definition of AI. For those that have been following up on the process regarding the AI Act, they may already be aware that the latest version of the definition of AI system is actually quite different from the previous versions of the AI of the definition of AI system in this whole legislative process. This last definition resembles most closely the definition as proposed by the Parliament, but still differs in some significant respects. And currently, the definition reads as follows. It's one sentence, but for this presentation, I divided it into 6 elements. So an AI system is a machine-based system designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Now, this definition is clearly inspired by the OECD definition, which has also been around for quite some time, and more specifically by the OECD definition for AI systems in their use phase. And if we take a look at that definition, we see that they define an AI system as a machine-based system that, for explicit or implicit objectives, infers from the input it receives how to generate outputs, which can influence physical or virtual environments. In the second sentence, they then also say that different AI systems vary in their levels of autonomy and adaptiveness after deployment. And there are two, I think, important remarks to be made with regard to this definition. First of all, the OECD definition was as such not meant to become a statutory definition. It was not meant to end up in a law. On the other hand, its purpose was to guide international discussions on AI policy, to streamline those discussions and find common ground on how to understand AI technology. Secondly, is the second remark is this second sentence, right? Because here we clearly see that the descriptive sentence that states that different AI systems can have various levels of autonomy or adaptiveness. But if we take a look at the AI Act's definition, we see that both autonomy and adaptiveness have really been integrated into the core fabric of the AI Act's definition of AI system. And so let's take a look at a few of the elements of this latest AI Act's definition of AI system. First of all, machine-based. That means, unsurprisingly, that AI runs on machines, according to the recital. But that is a bit of a circular clarification that doesn't really explain the scope of the machine-based requirement or the notion of machines. So for now, we will probably have to understand that AI systems should run on servers and chips, because at the end of the day, they are also some kind of machine. A second element I would like to highlight is this formulation designed to operate. What is interesting there is that we don't see any clarification in that regard in the recital, and that it's also absent from the OECD definition. But this formulation opens a potential discussion nonetheless. And the question becomes, should an AI system in operation actually demonstrate autonomy and/or adaptiveness? Or is it sufficient that it was only designed or intended to have these characteristics, although they may not necessarily manifest themselves in operation? Or what if it's the other way around, where a system wasn't designed to exhibit autonomy and/or adaptiveness, but does so in practice? Several open questions, and I admit resulting from quite a nitpicky comment, but this is a legal definition. So, and this legal definition has practical consequences, and so we should really be looking into every word. Let's move on then to this notion of autonomy. According to the recital, autonomy means some degree of independence from human involvement and some degree of capabilities to operate without human intervention. And so this clarification appears to equate the concept of autonomy, which comes with a highly philosophical connotation, with the much narrower notion of automation. And this can be illustrated by the example of industrial robots, which are typically able to perform a variety of actions independent from human involvement or operations without human intervention, but they do not necessarily rely on AI techniques to do that. They can, but they don't necessarily do so. And so we would usually consider that type of machine functioning to be automated, but not necessarily autonomous. But in terms of the AI Act, we may then have to change that understanding. And this is also further complicated by the use of adaptiveness, but more on that in a minute. Last comment with regard to autonomy relates to the use of this varying levels. Again, this isn't clarified in the recital, but leads to two important questions. First, if you read the definition from beginning to end, it reads as if the system at hand would need to be able to operate at not just one level of autonomy, but various levels of autonomy, as if there should be a switch that the desired level of autonomy. And undoubtedly, that's not the intention of the definition, but that's exactly the reason why this was removed from the OECD definition and was put in that second descriptive sentence, which I believe is the better manner to do so. And secondly, the underlying practical question of this varying levels notion is, what is then the minimum level of autonomy, or is it automation, that a system would need to exhibit in order to fulfill this autonomy criterion in practice? Now, let's return to autonomy and the related requirement of adaptiveness, because as explained, the recital seems to imply that we should understand autonomy as automation. However, this adaptiveness requirements seems to direct us towards a much broader autonomy concept. More specifically, the recital states that adaptiveness refers to self-learning capabilities, allowing the system to change while in use. Circling back to the example of industrial robots, this would mean that such robots would not only have to be able to perform automated procedures, but also be able to adapt their own operating parameters in order to perform new procedures in order to qualify as an AI system under the AI Act. And based on my current understanding of the definition, this brings us then to probably the most important open legal issue of this definition. Namely, are both autonomy and adaptiveness required to be considered an AI system or not? In legal terms, are they cumulative requirements, or is adaptiveness a facultative requirement? If we understand autonomy as a concept in a broader sense than automation, that would require adaptiveness. And so that is an argument in favor of cumulative requirements. The use of and at the start of this element also points in the same direction. However, the use of may and could in the related recital points in the opposite direction, indicating that this adaptiveness would be a facultative characteristic. Additionally, one also needs to consider that this will need to be translated into the other EU languages, which will inevitably further complicate this matter, as translations may use less permissive wording than the English version. For instance, in Dutch, I can imagine that we have a few possibilities to actually translate this into a sentence. And therefore, I really believe that this is a point that requires clarification, and ideally still even before its entry into force, because this really goes to the core of the scope of this definition. Another issue with the adaptiveness requirements relates to the fact that it's not entirely clear whether it's limited to adaptation due to changing circumstances, which are picked up by the self-learning capabilities of the system and have an impact on its function and the output, or whether this includes also adaptations after deployment as a result of intentional or explicit human intervention. Think about changing code, parameters, hardware, or maybe even fine-tuning or retraining processes. Probably this latter type of activities go beyond the self-learning capabilities of a system and should not be relevant to assess the adaptiveness of a system, but the question is still open. The last element I would like to briefly highlight is this notion of inference. So it comes with both a specific regular meaning as well as with a technical meaning, referring in general to the situation in which AI technologies generate output from input, typically after deployment, whereby you can imagine various types of inference, logical inference, probabilistic inference, and so on. Now, if you take a look at the related recital, it becomes clear that we should understand inference in its technical meaning. And it also, the recital also clarifies that certain techniques enable inference for AI, for instance, machine learning approaches and logic and knowledge-based approaches, whereby inference should in any case go beyond basic data processing and enable learning, reasoning, or modeling. I will, for today's purpose, not address the notion of implicit objective and influence, which can also lead to equally difficult discussions. Now, where does that result? What result does that then entail? Well, I think that the scope of the definition is currently rather unclear, and especially this discussion in relation to whether or not autonomy and adaptiveness will be or should be cumulatively required or not, does have a very important impact on the scope of the definition and will require clarification. A possible impact I foresee, therefore, on compliance at the moment, or possible compliance efforts, is that it may, in practice, be easier to first try to assess the relevance of the prohibited, the high risk, or the transparency use cases as listed in the AI Act, before actually trying to understand whether the technologies you're using in an organization would qualify as an AI system under the AI Act. So I think it's more practical to first narrow down the scope of your search for AI systems in your organizations by looking at the various use cases and then only really dive into the detail of the definition. What will the future bring us in this regard? The AI Act explicitly states that the European Commission has to provide guidelines on the practical application of the definition, but obviously that doesn't mean modifying the definition. And it also doesn't really say, it doesn't really include a timeline for publishing this application. With regard, the European Commission also had the obligation to provide practical guidance on high-risk AI systems within 18 months. And so if you would expect guidelines on high-risk AI systems, I think you can also expect guidance on the notion of AI systems in order to fully really achieve that purpose. So let's hope that they also publish clarification on that within a year and a half. With that, I leave this discussion for the AI definition, and I gladly pass on the floor to Matteo, who will address the scope of application.
Okay, thank you very much. So in the next slide, I will explore the scope of application of the AI Act. The AI Act can be described as generally regulating the placing on the market, putting into service and the use of AI systems, including generative purpose AI models. So it prohibits certain AI practices, for example, AI system that deploys subliminal techniques, distorting the human behavior or person behavior, introduces also specific requirements for high-risk AI system, as we will see later, and it introduces new transparency rules for some specific types of AI systems, such as AI system interacting with natural persons. Despite the diversity of areas covered by the AI Act, placing, putting into service and using AI system is kind of the common denominator of most of the obligation and prohibition reproduced in this slide specifically, but generally in the AI Act. So these are therefore crucial concepts to understand in order to understand the scope of application of the regulation. For example, whether the AI Act applies or not to our research organizations. So this is demonstrated once we look at more closely at the text of the AI Act. Direct reference to this act is made in several articles, for instance, on prohibiting certain AI practices. Look, for example, at Article 5.1a on subliminal techniques, which prohibits the placing on the market, etc. Indirect references are also made in other articles of the AI Act, addressing the obligation, directly the obligation of provider, deployers, or operators, all terms that imply an act of placing on the market, putting into service, or use of an AI system. An example here could be Article 52 on transparency of obligation for AI system and general purpose AI model intended to interact with natural persons. So in other words, in the large majority of cases, the obligation in the AI Act are addressed to either providers or deployers of AI system. And understanding who's the provider deployer means asking who is placing on the market, putting into service and using this AI system. So the relationship between this concept becomes evident when reading the respective definition. I've tried to reproduce this in the slides that you see. So a provider is a legal or natural person who develops indirectly or directly an AI system or model and places it on the market or put it into service under his own name and trademark, irrespective of whether a price is charged or not. In turn, placing on the market means the first making available of an AI system, namely the supply of an AI system or model for distribution or use in the Union in the course of a commercial activity. There is some uncertainty about what will be held to constitute a commercial activity. I believe that it would be particularly crucial in this respect to assess whether an organization gains some commercial advantage from making an AI system available or putting it into service. You can also be a provider if you put into service an AI system. The definition is somewhat similar to the concept of making available. It means to supply an AI system for first use directly to the deployer. However, two crucial differences are that there is no requirement for such an act to be carried out in the course of a commercial activity. And an organization will be considered a provider even when the AI model is not made available to the public at all, but simply integrated into the services of the organization. For example, you can think about a university that develops and uses an AI system for grading exams. Moving now to the concept of deployer, the AI Act defines it as the person who uses an AI system under its authority in the course of a non-personal and professional activity. Already in the definition, you can see that this is a somewhat subordinate role. In fact, the use of the AI system must be limited to the intended purpose, as instructed by the provider. It is therefore no surprise that the most onerous obligation under the AI Act fall on the provider. And finally, it should also be kept in mind that the reach of the AI Act is quite large, as you do not only need to be located or established in the EU to be considered a provider, as long as the product is made available within the Union. So we can see that the concept of provider and deployer generally defines the boundaries of application of the AI Act. However, the regulation also includes several specific exemptions that further redraw these boundaries. So I will start by mentioning 3 of them that will not, however, be discussed further. The first, it applies to military defense or national security purposes, regardless of the type of entity. The second one is instead on special for public authorities coming from third countries, and it only applies when these are acting within the framework of international cooperation or law enforcement or judicial cooperation agreements with the Union. And the third one, which is reflecting the definition of deployer, is that deployer is an exemption for deployer who use an AI system in the course of a purely personal, non-professional activity. Then we have 2 exemptions for research and 3 exemptions for open source AI. And I would like to look at them in a bit more detail because they raise some interesting issues. So the AI Act includes 2 exemptions for research. The first is aimed at AI for research, a term by which I mean AI models specifically developed to be used for scientific research purposes. This is a very important exemption, as without it, even research organization carried out a non-commercial research activity would have to comply with the obligation of the AI Act as provider, which is, as I show, in putting into service does not require any, there is no requirement of acting within the course of a commercial activity. This article can be contrasting with another exemption in the AI Act covering research in AI, a term which includes the testing and development activity happening before an AI system is placed on the market. 2 observations can be made. First, this exemption is better understood as a clarification. In fact, normally the trigger for obligation is the placing on the market or putting into service. As the legislative text makes abundantly clear, the exemption operates only prior to the making available of the AI system. Second, it also affirms that testing in real-world conditions falls within the scope of the Act, suggesting probably that such a testing in itself would be considered as an act of making available. Similar dynamics are also at play when in interpreting the exemption for open source. And here we have 3 exemptions. So the first one is an exemption for open source AI systems. It states that the AI Act does not apply to AI systems released under free and open source licenses. However, it then also specifies that all obligation under the AI Act, by which I mean obligation under Title II, prohibited system, Title III, high-risk AI system, or Title IV, the transparency obligation on specific AI system, will apply. For this reason, it appears more than a clarification than an exemption, strictly speaking. The other 2 exemptions, one applying to AI components and the other one to general purpose AI models made available under an open license, create a more lenient regimes in terms of transparency and knowledge sharing obligation for AI systems, models, and components that are made available on open source, possibly relying on the fact that open source licenses are allegedly intrinsically transparent, and thus such obligation would be considered redundant. A limitation of this exemption is, however, that there is currently no official definition of what open source means in the context of AI, nor clear means to establish whether a license is open source or not. Article 52 CA contains what is possibly an interim definition, or at least an indication of what the Commission may consider as an open source license. And I know that my colleague Ivo will discuss this in more detail, but we can say that this would be a license allowing access, usage, modification, distribution rights, and also making accessible the parameters and the information on model usage. And with this, I conclude what is a first tour de force on the scope of applications. And I hope it's clear that the paramount concepts are the concept of provider and deployer, to assess whether your organization or an organization fall within the scope of the AI Act. And I leave my word to my colleague, who will focus on looking at the risk categories contained in the AI Act. Thanks.
Thank you, Matteo. Hello, everybody. As a disclaimer first, in this part, I will try to map out risk categories, but provide an overview of that because for details, next webinar, my colleagues will detail the prohibited AI practices and high risk as well. But as a starting point, the EU AI Act is following a risk-based approach. What does it mean? It means that it doesn't aim to regulate all AI systems, but it specifically targets the ones who pose significant risk on EU principles and values. And with that, we can say that the Commission is using this pyramid of risk, which also receives several criticisms. I will come to that later. And the risk categories are from bottom to top is minimal or no risk to unacceptable risk. Unacceptable risk is the risk the AI practices in this area pose unacceptable risk, and it should be prohibited. I will give some examples in the following slides. But the core and centerpiece of this act is high-risk AI technologies. This is permitted as long as you follow certain requirements and obligations outlined in the act. We have also transparency, limited AI risk, which requires transparency obligations. For example, chatbots, and I will come to that later as well. And the ones called minimal or no risk, but we can call this unregulated or others remaining from the other list. So before delving into categories, just to, it's better to maybe dissect the notion from risk as a first part and then categories. So what is risk? If you do Control F in the AI Act text, you will find 765 matches of risk notion. And if there will be a competition among other legislative acts in the EU, AI Act would be the champion. And luckily, with the proposition of EU Parliament, we have now definition of risk under AI Act, just following the definition of artificial intelligence. And it says risk means the combination of the probability of an occurrence of harm and the severity of that harm. This is a similar mindset we have already seen in similar understanding we have seen in the ISO standards and also in the data protection context. And when we say harm, it specifically focuses on to ensure high level of protection of health, safety, and fundamental rights. You will see several references in the Act, and the risk-based approach in this regard should be tailored to different requirements for different level of risk would require different level of compliance requirements. And harm also explained briefly in the recitals. Recitals meaning that interpretative guide for public and also lawyers to understand what does it mean. And it says harm might be material or immaterial, including physical, psychological, societal, or economic harm, which is a broad understanding of harm. So I will continue with now categories. This is important to set the scene that AI Act is focused on certain AI practices, not all. And with the prohibited AI practices, we see Article 5, it says basically the spirit of this article is that certain AI practices, even with measures and mitigation measures, cannot be used in the EU. And for example, if AI systems that manipulate human behavior to circumvent their free will, or if it's exploit the vulnerabilities of people, such as their age, disability, or social scoring based on their social behavior or non-inferred predicted personality characteristic. We see some examples in the previous years with China on that. And biometric categorization systems that use sensitive characteristics. This is the important part, sensitive characteristics, following the similar mindset we have seen in the GDPR Article 9, special categories of data processing, and untargeted scraping of facial images from the CCTV footage to create facial recognition databases. We see also the what's happening in the previous years, for example, with the Clearview AI. So these prohibited AI practices should be seen as a red lines for EU. But of course, we have also emotion recognition prohibited in workplace and educational institutions, and there are exceptions for medical and safety use, and law enforcement use of real-time biometric identification in publicly accessible spaces. This was also resulted in heated discussion in the previous year. And we see, just to note here, that there are limited exceptions for some of those prohibited AI practices, especially for law enforcement use. And for the last one, real-time biometric identification in publicly accessible spaces. This is important because it doesn't cover digital environments, or it doesn't cover border control, or it doesn't cover prisons. And with limited exemptions, it can be still used, but at least with further measures defined in the leaked text. So to understand really whether you will fall under this prohibited AI practices, it would be really necessary to take a nuanced approach to follow the word by word, the act, because sometimes it says a cumulative approach or sometimes it says only for this context, for example, as we see for the law enforcement. And I will continue with high-risk AI systems. For high-risk AI systems, as I said, this is the core part of the act, actually, with outlining several requirements and obligations for providers and deployers. It has two different categories. The type 1, which is for more product-oriented, which there are a list of directives and regulations targeting certain products. Plus, those products should also require a conformity assessment, which is outlined in Annex 2. And we have also second type, which is more sector-specific and purpose-oriented. This is also a list of uses under Annex 3. Why I'm referring here to annexes, and maybe for audience, what does it mean annex at all? Annex are a part of the act, a documentation, which helps maybe a convenient way to update or modify the text in an easier way without delving into details of the main document text. So we should see annex as a collection of maybe the concise list of relevant regulations or directives here, or specific uses. But the thing is, considering the evolving nature of AI, it would be necessary, and I will come this later, it might be updated. So let's continue with the type 1 high-risk AI systems. We have two cumulative criteria here. First, AI systems intended to be used as safety component of a product or itself a product, covered by the Union harmonization, as I mentioned in Annex 2, and the product is required to undergo a third-party conformity assessment. So which products we are talking about under Annex 2? Under Annex 2, we have two different sections, Section A and Section B. Section A products are covered here, for example, toys, medical devices, lifts. So if the AI system is intended to use in this products, then this is a type 1 high-risk AI system. Of course, if it has also third-party conformity assessment obligation. But here we have an exception under Article 2.2, which also refer to Annex 2, Section B. There are a list of regulation and directives, for example, including interoperability of railway systems, civil aviation, motor vehicles, so on and so forth. So for these kind of regulations, the AI Act will not be applicable. This is important to note to make the distinguish. So let's continue with the type 2. This is the high-risk systems by default should be considered. And we see here biometrics, critical AI used in critical infrastructures, transport, heating, water, electricity. And we see AI used for educational vocational training in the context of employment as well, essential private and public services. One example could be credit scoring, denial of the credit scoring, and the use in law enforcement context, which might interfere with people's fundamental rights. We see also use in migration, asylum, border control management as a high risk, but there are sub-list of uses under Annex 3. So it's important to follow in detail to see the real implication and also administration of justice and democratic process. We have also type 2 exceptions here. AI Act says that under Article 6.2, if companies, providers, or deployers think that their AI system doesn't pose significant high risk, significant risk of harm for health, safety, and fundamental rights, then they might be outside the scope of the this categorization. Basically, there's a room for staying outside of this high-risk obligations and requirements. But there are certain categories and lists mentioned here, like if your AI is performing a narrow procedural task or improve the result of previously completed human activity, so on and so forth. So it's important to consider this exception. This requires maybe conducting a fundamental right impact assessment, or something we use to know data protection impact assessment, which are different but sometimes in parallel. My colleague will explain in the next seminar as well. And here, one thing is very important, that if AI systems shall always be considered high risk, if the AI system performs profiling of natural persons. This is very important. So even if you say that there could be some exclusion exemptions, but if it's profiling, then it's high risk. And let's continue with the limited risk AI systems. Here we see that certain AI systems intended to interact with natural persons or generate synthetic or artificial content, then there could be a specific risk not being recognized as such. And therefore, AI Act tries to mitigate that risk by ensuring that individuals are informed well and transparency obligations are met. So basically, as an example, interactive AI systems, chatbots, biometric categorization or emotion recognition. So if you are using the system, you need to inform natural person exposed to those technologies. And also for deepfakes, you need to inform the artificial nature of the content. With this, we see, as you on the top right, you see Pope Francis with Balenciaga code. This is one of the well-known photo, maybe from the last year. So the impact of deepfake and synthetic output is growing, but also measures to mitigate those risks as well. For example, Adobe proposed a CR technique to watermark some deepfakes, and Google recently, last August, Google DeepMind proposed a technique called Synth ID. As you see on the image, they work on the pixel levels to identify the content as synthetic, artificially made, but without interfering with enjoyment of the work. For example, maybe this is good for meme lovers community. And let's continue with the last one. Actually, in between or even in the limited risk AI systems, there are reference to the general purpose AI, but here I will leave this to my colleague Ivo without referring more, but for all general purpose AI systems, transparency requirements will be applicable. For the remaining part, the minimal or no risk part, we can call this other AI systems. And for this one, there is no specific regulation, obligation under the AI Act, except complying with general product safety standards, of course. Nevertheless, we see that Commission is pushing towards voluntary compliance and establishing code of conduct in this realm. But just to note that ethical principles will remain applicable for sure, even if you say that my product or my technology will be outside the scope of the rest of the categories and it will fall under the no risk categories. So examples are given as AI-enabled video games and spam filters, etc. Now I'm yielding floor to my colleague Ivo, but before closing that, just a quick remark that for detailed analysis for prohibited practices and high-risk technologies, next webinar my colleagues will cover that aspects in detail. Thank you so much.
Hello everyone. So I believe, the geekiest topic today. General purpose AI models. Why is it the geekiest? Some of you may remember the controversy around foundation models. Do they belong in the AI Act? Do they not? What are they even? Because even the authors of the original paper from Stanford, Bomasani, and many others, in the paper themselves, they say there is not really a precise technical definition of what this is. So then I wondered, if there's not even a precise technical definition, should we even have a legal one? Now, luckily, what we ended up, well, I don't know if we're lucky really, but we're going to see what we have now in the AI Act is so-called general purpose AI models. And first and foremost, we need to distinguish the models from the system. This is something that the regulation specifically mentions, saying that the notion of general purpose AI models should be clearly defined and set apart from the notion of AI systems to enable legal certainty. So far, so good. Now, the difference, regulation says, is based on functional characteristics of these models. So that's, and then the references to vague concepts kick in, such as generality, or the capability to competently perform a wide range of distinct tasks. Well, I can think of at least 15 tasks that ChatGPT cannot competently perform. Yet, the GPT-4 that underpins ChatGPT would still be a general purpose model. So, I mean, references to concepts with really vague meaning doesn't help much. Anyway, the AI models to become AI systems should require some further components, as regulation says. So, for example, you should have at least the basic user interface. Now, I'm curious as to if I, for example, download Mistral 7B and I load it onto my MacBook and I start inferring, I already have a basic interface. Is that now an AI system or not? See, it's also not as clear-cut. But anyway, my main point here is to say general purpose AI models are really foundation models in disguise. So many of you know the transformer architecture that underpins general purpose AI models, and the foundation models or whatever, is a greedy architecture. So it's tightly linked to compute. Now, the problem is that the transformer has basically reached its limits. Every time you submit a prompt to GPT-4, for instance, you kick in all 1.76 trillion of the model's parameters. They're activated to produce a response. So this is computationally expensive, environmentally unfriendly, and it's also close to the limits of large language models. So we no longer have more data, basically, that we can use to produce practically to scale these models further. And that's an observation that many in the community share. So because these models cannot scale, I'm skeptical of the way they're regulated in the AI Act. So we have two main categories of GPAI models. First, I call them conventional GPAI models because they don't have any other name in the Act. These conventional GPAI models can be proprietary or open source. Matteo already mentioned when they're open source, there are no transparency obligations because these obligations are allegedly met by the models being open source. But there is a requirement for providers to disclose the training content they've used. So this should be sufficiently detailed, but not really a work-by-work analysis, just a sufficiently convincing narrative, I would say. And they should also have a complementing copyright policy. Now, conventional GPI models do not really present many risks, so that's how the AI Act systems. Now, conventional AI, GPAI models would be all models by definition that require general compute power of below 10 to the 25 floating point operations. Now, that's a presumption. So if you go above that, and GPT-3 required 10 to the 24 floating point operation, so you can see the threshold. If you go above that, then there is a presumption that this is a model with a systemic risk. And one way of a model being classed as a model with a systemic risk is either if it goes above that threshold or if the European Commission designates it individually. How does the Commission do that? Typically on the basis of, the idea is to do it on the basis of qualified alerts by a pool of independent experts. So for example, somebody in the scientific community observes a model and they see that it meets more or less the criteria for for presenting a systemic risk, then they can notify the Commission and the Commission can act independently. They assume that in the beginning, at least, the quantitative criterion of floating point operations is going to be the main. So what is a systemic risk? Well, the way I read it, again, the definition is a bit vague, but the way I read it is the model should present high impact capability. So again, these competently and competently performing of tasks and generality requirements. There should be actual or foreseeable risk to fundamental rights and other values, such as public safety, health, and so on. So this actual or reasonably foreseeable is something that we're going to argue quite a bit, I believe, in the future to see whether you could reasonably have to see a risk in order to class it as the model as posing systemic risk or not. And then there must be a good chance for the risk to be propagated across the entire AI value chain. So for example, if the model becomes quite popular, chances are that you may end up in the situation of a systemic risk. Now, when we're talking about GPAI models with systemic risk, it doesn't matter whether it's open source or proprietary. So they fall under the same regime. Now, who are the providers of GPAI models? Well, they are the main addressees of the regulation. They already mentioned that whenever they place on the market the model, irrespective of whether they are based in the EU or not, they are subject to the requirements of the regulation. What obligations do they have? Well, when it comes to conventional GPAI models, they need to furnish technical documentation of the model, information for integrators or downstream recipients should be able to understand the model. They should also provide a copyright policy and a detailed summary about the content used for training. Number 1 and 2 do not apply for open source models. But now the tricky element here is that, as Matteo mentioned, we don't have a definition of an open source license for AI. Now, the Commission and the Council and the Parliament have tried to introduce sort of a definition. The problem I have with it is that it's not really recognized by the communities as such. And in open source, you don't do things without asking the community first. That's one. And the other is that there seems to be an additional requirement for public disclosure, which is not a requirement of any really open source license. So you have to provide the source code if you're asked, and you may provide it online, for example, in a repository if you so wish. But this is not a requirement of any open source license. So whenever somebody approaches you and they ask, can you give me the source code? If your product has been released under an open source license, you have the obligation to furnish the source code. But you're not really obliged to publish it for everybody to consult, just like that. And yet the legal definition here seems to introduce this requirement on top of everything else. And the other concern I have with this definition, with this approach, is that the dominant approach currently at the open source initiative towards open source AI is to define it at the level of a system. They don't have a definition for open source AI model. We have a definition of an open source AI model in the AI Act. How the two of these are going to work out, I don't know. But as I said, in open source, you don't do things without asking the community first. The what? So what are the obligations when it comes to systemic risks? There are some additional obligations for providers of general purpose AI models, such as model evaluations, assessment and mitigation of resources, cybersecurity compliance, and also reliance on codes of conduct. So codes of conduct, at least for the first, I think, a year or maybe 2 years, will be the main approach to achieving compliance. And then there's going to be a harmonized standard that's going to be published, and hopefully providers will be able to subscribe to it and follow its provisions. And then the when, so when should you panic? You should not really panic, I hope, but these provisions will start applying as of month 12 from the date of entry. So let's assume the act is adopted in April. As of April 2025, these obligations will be in force. Codes of conduct should be ready by basically the beginning of next year, and the Commission may impose some fines not exceeding 3% or 15 million euro. But these will only be applied 1 year after the entry into application, so not before April 2026. So I hope that helps, and I look forward to the discussion after Katerina's presentation.
Thank you, Ivo, and I'm the last presenter for today. So let's go quickly through regulatory sandboxes, and I designed the presentations in a way that it suits the webinar, kind of. So it's about 5 things to know about regulatory sandboxes for AI, or the so-called AI regulatory sandboxes. So we do have a definition in the latest version, the version that we expect to be adopted. And this definition you can see on screen. It defines those AI regulatory sandboxes as concrete and controlled framework set up by a competent authority, yada, yada. So how did we end up with that? It was quite a journey, basically. Here you can see how the different versions that we had through the years actually was going back and forth between several elements of what a regulatory sandbox for AI should mean, or it means, because nobody really knows yet. And the thing is that I would say that the motions that were mostly discussed was, first, are we talking about a framework or are we talking about an environment? And it's important because if we're talking about framework, we're more talking about a process, while with an environment we have, or at least I believe that we can have several different elements, including like a testing, experimentation facility, depending on the sandbox, and some additional things like relationship with an innovation hub, and so on and so forth. But apparently, in the latest version, we set up on the process, like being a framework. And of course, the second element of this going back and forth was it was about control. And that's very interesting that even though we initially were very much set into having it defined as controlled environment, so basically there is no room for real life experimentation, there was a lot of criticism and justified ones. So eventually what we compromised was that we would have it as a controlled environment, but in certain cases there would be possibility for real life experimentation, and that's kind of crystallized in the new articles 54A and B, where you actually have something which is kind of a weird concept, but it's basically the possibility to test high-risk AI systems in real-life environment outside of the sandbox. That's literally how it is defined, outside the sandbox. So one would wonder, why would you need the sandbox then? But yeah, our approach is definitely very different compared to other places around the globe, other jurisdictions, because regulatory sandboxes are not a new phenomenon. And up to this moment, they were mostly used to test various product, services, and business models, which the business model completely disappeared from our understanding of it. And it was done in certain highly regulated areas like finances. So naturally in finances, you have fintech, you know, and then you can have different technologies, AI including. And AI systems and services, they were tested inside sandboxes for fintech quite successfully, I would say. But now, for some reason, we decided that we need a dedicated sandbox to artificial intelligence, and we're going to see how this is going to work. But it's very different compared to what the UK approach, for example, is here, because I mean, they're not big fans of definition when we're talking about these tools, but they still define it in the white paper for AI as a live testing environment with a well-defined relaxation of rules. As far as relaxation of rules goes, the AI Act does have something that we're going to look in a second, but I would argue it's not really that tempting for the business to participate. The second and the third thing that I would like to discuss related to AI regulatory sandboxes is how does it work and look like, and who are the involved stakeholders, because that's obviously important for those who still want to participate. It's really not different than the traditional sandbox model that you have. You have an application process with predefined criteria, which could vary. For example, if you look at, again, the UK example, since they are the place where regulatory sandboxes begin their existence. So there you have a criterion that's like novelty of the product or service. You have also things like an ability for the participants to actually interact with the regulator in any other way, which it's intended to stimulate SMEs to participate more in such frameworks. Then you have the participation, which has a few subphases. So you have a testing plan that's designed between the participants and the regulator. Then you have the testing, which can, of course, depends on the capabilities of the sandbox. It can involve even provision of data sets, or it can involve relaxation of rules, even though the AI Act doesn't say explicitly. I believe that if the law of the certain member state allows it, it is possible to be done, as long as, of course, it doesn't stem from EU rules, because national authorities do not have the power to lift rules that come from EU law directly. And the last phase is, of course, evaluation, which in our case is going to have a very detailed reports that are going to be published for transparency purposes. Now, what's important here, and why I'm even bothering you with this, is that actually there is an obligation for each member state to have such a functioning AI sandbox after 24 months after the regulation enters into force. So this might seem like a lot of time, but actually it's not. And why is that so? Mainly because we vary across Europe into how familiar we are with this concept. There are member states like Germany, like the Netherlands, where they were practicing with sandboxes in different domains, so they do know how this potentially should work for them or what should not work. But there are other jurisdictions like my native Bulgaria and also like Belgium, where we do not have the necessary experience. We are still to determine things like, in Belgium's case, who is the competent authority. And for Belgian lawyers, you know, this is quite a fuss that we still need to overcome. And yeah, we need to, in some cases, even adopt additional legislation, which is a timely process. That's why it's very important for all the member states to actually start working on this as soon as possible, and as soon as possible might mean yesterday in this particular case. Because as regard to who are the stakeholders that are involved, besides the participants, which could be SMEs, they can be public organizations, basically everyone who wants and needs to test some AI-based system that's a product or service and has the necessary level of innovation. And the other participants from the public sphere, those should be the regulators. The competent authority for AI for sure, but also it was stressed by the regulation that the relevant data protection authorities should be mandatorily involved, especially when we have processing of personal data. But you can also have other competent authorities, really depending on what the AI system that you want to test does. Because if you're testing a fintech in an AI sandbox, it's absolutely normal for the financial authority to be involved in the whole process. How they're going to coordinate, this is a very different story. And in all fairness, the Commission is planning to adopt this implementing act, which is supposed to basically cover all those unanswered questions about eligibility and selection, the procedure itself, and the terms and conditions. I personally don't know how this is going to look like at the end, but what I would say is that while I do see the need for having standardized rules regarding the sandbox, it's very important to leave for the member states some room to maneuver, so they can basically have their specific needs answered by the sandbox, and not just not do it because the AI Act says that they need to do it. Very briefly about what are the incentives of the participants. there is indeed a possible relaxation of rules, which is defined in Article 54. And it's basically that in an AI regulatory sandbox, personal data, which is lawfully collected for other purposes, may be processed solely for the purpose of developing, training and testing certain AI systems in the sandbox. But this is subject to very big number of conditions, including that the AI system must be developed for safeguarding a substantial public interest in areas like public safety, health, etc., that the data processed must be essential for meeting specific regulatory requirements, that there should be effective risk monitoring, mitigation, and so on and so forth. I wouldn't say it's impossible to actually use this leeway, but it's very hard to do so. At the end of the day, I feel that the main advantage for participating in AI regulatory sandboxes in Europe would be to have this direct contact with the regulator and together to figure out how your innovative product or service would work. So it could be potentially in conformity, because of course that would be only by the exit point of the sandbox, since there is a life cycle that can change everything, and there is no presumption of compliance once you exit the sandbox. It's more about reputation. That's for me, and if I'm going to give the floor back to Thomas, and if you have questions I can't answer, please reach out to me, social media.
Thank you, Katrina, and also Matteo, Ivo, and Abdullah for your great presentations, I believe. Now, before ending the recording, I would like to point out that there is a second part to this webinar on March 14th, which will also take place between 12 and 1, which you can register to via the QR code on the slides. During that webinar, we will dive into more detail into the high-risk categories, the prohibited categories, but also look into conformity assessments and, for instance, the fundamental rights impact assessment, which was added to the latest version of the AI Act. Now, before ending the recording, I think I identified a few questions that I would like to add to the recording, as they probably may be also of broader interest to not only the people participating today. So I will try to reformulate them and put them for one of the presenters. So a first question for Matteo, maybe. One of the questions in the chat related to the difference between a user and a deployer. Right, in the initial versions of the AI Act, there was this notion user, which was then replaced by deployer, but the AI Act still employs the word use and user in other sections. So can you maybe briefly comment on the difference between the two, and or if that should change?
Yeah, so I think that the term user that was used by the AI, the Parliament in the Parliament version especially, was a bit misleading, and the reason is that we should look to understand the concept of provider, deployer, and also ultimately by negation also user. We need to look at the value chain. For instance, even when you have a deployer, that always implies that there is a provider. And most of these obligations only work in that way because the provider creates the instruction, creates what is the intended use, and then gives access to the deployer to the model. So here the deployer would be, as I made the example of a university that receives an AI system from a provider and then simply uses in the course of their services. Then there may be other type of actors that we could see, such as affected parties, the students. Those were what we would normally call users, probably. But so this is the distinction between deployer and user. The concept of use is never defined in the AI Act, as I said. The only thing that is defined is the intended use. But again, this is something different than the end user. So I would always think about these categories in the value chain of the AI value chain. Provider that provides the system to someone who integrates in their services, which would be in this case a deployer, and then there may be affected parties that could be called users. I hope that's clear.
Yeah, for me at least, yeah, but I do indeed have a bit of a background in the AI, but I think that your clarification was very good. The second question then for Abdullah, and that's maybe a bit of a twofold question. First of all, there was a bit of discussion on the faith that industrial cobots may end up under the AI Act. And what type of risk category could they fall, supposing that they do indeed rely on AI systems as defined by the AI Act? And the second part of the question is in relation to deepfakes. I saw that some participants to the webinar argued that deepfakes, or at least in a situation where they would be called a deepfake, that they're no longer fake. But does that reasoning actually hold under the AI Act or not? Abdullah?
Yeah, thank you so much, Thomas. So let's start with the second question. So the deepfake, now we have a definition of deepfake under the AI Act. As you know, with the recent year, we saw a lot of synthetic and artificial data, and especially it might affect votings and elections. So because of that, it would become very important to detect those synthetic informations. And deepfake is like the reference I made for limited AI risk systems was for the deepfake detection. So once those output is detected, it would have less impact for sure. So we should see from that angle. I hope this clarifies a bit. And for the first question, can you repeat, Thomas, for what kind of robots you said?
So the industrial cobots, so the typical industrial robot on an assembly line, how would that be categorized under the AI Act?
Yeah, like this should be considered as like a product, or like maybe a part of that product could be an AI, or the product as a whole could be an AI. So we should take into account Annex 2 in that context, and we should see whether this will be fall under Section Section A of the Annex 2. And if this is the case, then we should check the cumulative criteria mentioned there. So first, if it is the part of AI system or AI product itself, and also whether it's subject to third-party conformity assessment. If both those criteria are met, then AI Act will be applicable in this case.
Yeah, I think you need to add to that answer that industrial cobots may end up being considered as machinery and may fall under the machinery directive regulation, and that hence they will be high risk, a type of high risk AI system, supposing that they do indeed rely on AI technology. And then I also saw quite a bit of a discussion on the open source nature, right, of models like Mistral's and Meta's Llama model. And I think that is indeed a very interesting topic, right, because they say that they have open models, open source models, what have you. And I think Eve already addressed that question a bit, but maybe expand a bit further on that, right? Are they open source, free and open source in accordance with the AI Act, in your understanding, or not? What implications has that for people using those models?
Well, I've already been discussing with some of our participants in the chat precisely about that. To me, there is really, I have to be honest, there is just one organization right now that truly releases AI models as open source, and that's the Allen Institute on AI. It's a US-based organization. You may check their approach to open source AI, but they have a very strict set of criteria on what exactly counts as open source. And to me, that's the closest we've come to true open source release. I'm going to post a link to the website so you can check it out. But other than that, I don't think right now we have anything remotely close to an open source model, at least not in the way we understand open source traditionally. Because let's not forget, there is a community agreed definition that is being stewarded by the open source initiative. And like I said, you do not play with it without consulting with the community. And the process on defining open source AI is currently ongoing at the open source initiative. We've had the chance to contribute to this debate, but it's still pretty much a work in progress. We cannot even agree whether we should be defining open source at the level of an AI system or at the level of a model. And now I'm concerned that in the AI Act, we have a binding rule on what exactly should count as open source AI. And the disclosure, for instance, of training data is not part of that. And many in the community have argued that without that, and AI, the Allen Institute is one of these organizations, they say without that, without disclosure of training data, you can never have truly open source models. So I don't know how that's going to play out in the end, but it's definitely something to follow up. By the way, the process of the OSI is transparent. So if you want to contribute to this definition, please do so. It's done via Markdown, publicly available. Everybody can contribute to this. So if you have ideas, please visit their website and file your contribution.
Okay, thank you for your clarification on that topic. Katerina, I tried to quickly go through the chat, but I haven't managed to look into the details. But are there any questions that you would like to address from your regulatory sandboxes perspective?
Just maybe one, because it was more like not a question but a comment about sandboxes being innovation killers. I would say that it's not necessarily true. Depends really how the sandboxes is done. And I think that I started with the definition, but with all honesty, I'm not really that much of a fan of having definitions of regulatory sandboxes, precisely because the way that it started was because you had a problem, you needed a solution, and you needed to think a bit out of the box. And then we started talking about other tools like regulatory sandbox, like test beds, policy labs, living labs, and now they, for some reason, are used interchangeable, but they are not the same. And we should not really focus that much on the form, on the shape. It's more about if you have a problem which requires testing of certain systems, and then fine-tuning them to your existing regulation, then do it, and do it the way that it suits your use case in your particular state or even your particular region. So that's what I wanted to put as an emphasis. It's not necessarily a problem with the sandbox, it's the way that we fixate on definitions and on how we should regulate it when we just need to, go with the flow of innovation with the sufficient guarantees and just learn. You can't learn in such a highly controlled environment.
Yeah, interesting comment indeed, and I think a very interesting opinion as well. So for this webinar's purposes, I will now stop the recording.